Okay, thank you all for joining. Um, Hello everyone, and a warm welcome to today's 15-minute bite-sized insurance webinar. I should start by saying that the talk is aimed at liability adjusters rather than first-party ones. I am Virginia Hickley. I've been at Mills & Reed for 18 years, and I've been a partner for over 13 years. I specialise in professional indemnity insurance litigation, and although I'm normally based in the London City office, I'm streaming to you now from my home in North London. I'm joined today by Charlie Andrews, my colleague. And for those of you who don't know Charlie, he qualified into our London insurance team in September, but he hasn't always been a trainee and a law student. He's done quite a few different jobs in the past, including working as a chef, a tractor driver, a gamekeeper, and he even spent 3 years working as a chartered surveyor with Stratton Parker. But most relevantly for today's purposes, just before qualifying in September, he spent several months of his training contract on secondment with an underwriting agency as a claims adjuster. So he has some idea of what it's like to be in the thick of it with notifications coming in. And we've put this talk together with a view to bringing some structure to the claims adjusting process, which brings me to what we're going to talk to you about today and the introductory slide. So I'm not proposing to read that out, you can read it yourself, but these are the signposts around today's talk. Today's talk is intended to be a checklist to help you adjust claims more efficiently. The webinar will be suitable for you if you are an entry-level junior adjuster, or it's a refresher of the basics if you're more experienced. Understandably, the bent here is on professional indemnity, which is where our experience lies. But no matter what your level or area, I think it's useful to bring some structure to the claims handling process that will make the process both quicker and more thorough. I'm sure you don't need me to tell you that there's more to claims adjusting than can be done by way of cradle to grave review in 15 minutes. We're ambitious, but we're running this series in such a way that Charlie are under orders to wrap up, including questions, within 30 minutes. So it's fair to say that our aim will be to provide pointers rather than answers to each and every scenario. Before I hand over to Charlie, I have a poll. So the question is, do you reserve your rights to your insureds as a matter of course? I'll just let you have a few seconds to vote on this question, and then perhaps we can share the results when ready. 68% say no.
Yeah, so I think that's largely what we're expecting to see here, really. Normally, well, sort of historically, this was the standard approach to claims coming in. The first thing that the claims adjuster would do would be to reserve rights. And looking at the polls, it would appear that times have changed. In our opinion, reserving rights without having reviewed coverage is quite an aggressive way of responding to a notification. And you're essentially saying, despite the fact that we haven't checked, we don't think this is covered. And that's just sort of not, in our opinion, not a great starting point. We would prefer to properly investigate coverage at the start using our checklist if you find it helpful. And then in most cases, you can confidently confirm cover and then move to the next step. Do you have anything to add to that, Virginia?
No, I think the reservation rights, often it's in place because there may be a concern, and therefore that might count for their sort of percentage where they do as a matter of course. But yeah, no, not really. I'm happy for Charlie now, if you take over the mantle and put through the early stages of the life of a claim or circumstance.
Perfect. Thank you, Virginia, and good morning to everyone. So notification of a circumstance. How you deal with this is really important, and it will set the tone for your dealings with the insured going forward. And remember that the lifetime of a claim can be several years. So I think it's quite important to start off on the right foot. The first thing to think about is it a circumstance? Could it perhaps be a claim? or potentially it might be neither. And remember that the definitions will be different in every single policy that you look at. It can be really dangerous to assume that only letters of claim or proceedings are a claim. When you look at your claim definition, often it will require something along the lines of a demand for damages, but it may also include the threat of proceedings, and they're really quite low thresholds that could be met really easily with a single line in an otherwise dull email, or it can even happen over the phone. So just be really careful with that one. The definition of a circumstance is just as important, because if a notification isn't a circumstance and isn't also a claim, then it shouldn't be noted against the policy. And if a circumstance isn't noted, then if a claim arises in the future, even if there's a new policy in place at that time, then the claim will attach to the policy that the circumstance was noted against. So again, look really carefully at the definition of a circumstance. It may say something along the lines of an allegation of negligence or a complaint. And now that will obviously require some correspondence from the potential claimant. And the insured ideally will provide this with the notification, otherwise you'll need to ask for it. But the definition may also refer to the insured having identified a shortcoming in its own work. And now this threshold can be met without any correspondence from the potential claimant. And so therefore you really need to dig down in what the insured thinks he may have done wrong. The policy may also refer to matters that are likely to give rise to a claim. Now in this context, likely will mean that there is more than a 50% chance of it turning into a claim. Alternatively, the policy might refer to matters that may give rise to a claim. And now this is obviously a lower threshold, and it means that there is more than just an outside chance of it developing into a claim. And now I appreciate that that is typical lawyer speak, and unfortunately you will just have to deal with these on a case-by-case basis. Sometimes you'll get notifications where the insured has just been spooked by something that their former client has done, and that there hasn't actually been a complaint, and that the insured isn't able to identify anything that they might have done wrong. So I had a recent example of this where an insured's former client requested a whole heap of documents from them. And now the insured was probably quite understandably actually worried that the reason they were doing this was so that they could build up evidence for a claim against them. But no one could identify what the claim might be about. And so this wasn't a circumstance. Remember that the policy will also have notification requirements. And for example, the insured may be required to notify in writing, that's a pretty standard one, provide the potential claimant's name and provide the details of the potential claim. And you should make sure that you have all of this information before properly commenting on coverage. Policies will also require insureds to notify within a time frame, and that's usually something along the lines of as soon as possible. So what does as soon as possible even mean? Is a week okay? How about 2 weeks? Now, it will all depend on the circumstances, but if it needs to be notified as soon as possible, then 6 weeks probably isn't okay. Now, that's another lawyer answer, I'm afraid, where I haven't actually given you an answer. But another way to look at it, and another question perhaps to ask the insured is, do you have a good reason for sitting on it? Why haven't you notified? If proceedings are issued, then ordinarily you might expect the insured to notify this immediately because there's really tight deadlines and proceedings are really quite serious. But do try and remember that most insureds aren't experienced litigators, and it is often not unreasonable for them to underestimate the seriousness of the letters that are coming through. And this is especially the case with insureds who don't think they've done anything wrong. You next need to look at and ask when the insured first became aware of the issue. Because if they were aware of it prior to the start of the policy, then this is a crucial coverage point, and insurers may have grounds to decline or possibly pass the claim back to the previous insurer. So what do you then do if the insured sends you a really broad notification relating to a number of potential claimants and a number of potential problems? Now, this is what we would refer to as a blanket notification. There's a real danger with these sorts of notifications that if you accept them, then you end up with an unquantifiable but potentially really large exposure. And this is where you need to really pay attention to your policy definitions and the notification requirements. And with those, you need to be asking the insured for as much information as you're entitled to. You need to be asking who is or who are the potential claimants, and what have you alleged to have done wrong. And ultimately, this clarity will benefit the insured too, because a blanket notification won't do their renewal premiums much good. It can take time to work through the checklist properly, and it's really important not to rush it. As I said before, it's in the insured's interest that you properly review a coverage, because in most cases, this will allow you to confidently confirm cover and move on to defence. And in my experience, it's the umming and ahhing and the not making decisions and dragging things out and not keeping the insured in the loops. That's the sort of thing that sours a relationship with the insured. So now that you've worked through your checklist with this notification, can you now confirm cover? If you can, be really clear about what you're accepting so that you can avoid any arguments in the future. And if any questions remain, is now the time to put a specific reservation of rights in place. Okay, so let's move on to what happens if we get notification of a claim. Here we go. Then we've got our claim form that's just come in. What do we do now? So first, we need to assess the facts and look at whether this claim relates to an earlier circumstance. If we're dealing with a claims made policy, which most professional indemnity policies will be, then the claim will attach to the policy that the circumstance was notified. And that's why the steps that I discussed a few minutes ago are really important. Once you've confirmed cover, you need to start thinking about how you're going to defend the claim. Are there any urgent steps you need to take, like acknowledging service? Or is there something that the insured can do quickly to fix the issues, preferably without admitting liability? This is also probably a really good opportunity to remind the insured about their excess and how this will work. Now, this isn't a hard and fast rule, but it's just good practice, and it will avoid awkward surprises later down the line. There's nothing that quite holds up settlement, like the insured suddenly remembering they have a £100,000 excess that they're going to need to find somewhere. And so now we move on to the rather dry topic, I'm afraid, of the pre-action protocols, which I will make as interesting as I possibly can. And these dictate how the parties should act before they file proceedings. And as you might expect, parties are expected to act reasonably, but of course it doesn't always work that way. So you've got a rather daunting letter of claim in front of you. What do you do now? Well, you need to be asking whether the claimant should have complied with the pre-action protocol. And the difficulty here is that there are a number of them, and it's not always that obvious which one applies. So what you need to be doing is, the best way to do it really is to do a bit of a Google search, put pre-action protocol in, and then put the name of the sort of professional or who it is that's being sued into Google, and just see what comes up. And the things to look out for with the protocols is, does the letter of claim set out a chronology? Does it give you the key documents that you need to assess liability? Does it specify the allegations? Does it explain how breach caused the loss? Now, this is really important because, and this is something that Virginia will touch on shortly, it's entirely possible to be negligent without causing a loss. And does it specify the loss, preferably in pounds and pence, could be some other currency. And don't assume that the letter is right just because it was drafted by solicitors. Those of you who work in solicitors' PI will know that we are all more than capable of making mistakes. Crucially, the protocol will set out the deadline for your response, and each protocol has a slightly different process for dealing with deadlines. But as an example, the protocol for professional negligence gives you 21 days to acknowledge the claim, and then 3 months from the date of that acknowledgement for your full response. So here it can be tactically beneficial to delay acknowledging the claim until the last minute. But of course, you don't want to miss the deadline. Then think about whether you need some more time to provide your full response. If you do, then you need to speak to the claimant as soon as possible, as the courts have almost no sympathy for people who wait until the last minute before asking for an extension, especially if it was really clear from the start that you weren't going to have enough time. all the way through this process, you need to be asking yourself, am I being reasonable, even if the other side aren't? And if my actions were to come in front of the court, what would they think of it? Then someone's going to need to prepare the response. Can the insured draft their own, or do you need to get solicitors to assist? Now, this will depend on the numbers involved and the complexity of the legal points. And I sort of touched on this before, but this might seem like a really obvious point, but please put the deadlines in your calendar. It is really embarrassing if they get missed, and the claimant may issue proceedings without further notice, resulting in significantly increased costs. And what if proceedings have been issued? Well, generally speaking, you will have 14 days to respond, and that deadline is extended to 28 days if the insured acknowledges service. So if you're going to appoint solicitors on defence, you need to do this as quickly as possible so that you have enough time to review the papers and discuss the background with the insured, obtain instructions, and remember they're going to need to get instructions from both you and the insured, and start preparing the response. Solicitors may also need to appoint counsel to draft the defence, and this is another step that takes time. The claimant may ask the insured to enter into a standstill agreement, and this is essentially an agreement that stops the procedural clock and gives you more time to consider your response, which sounds perfect, but you may not always want to agree one. Sometimes the delay can end up costing more, and also remember it gives the claimant time to build up their own case as well as your time to defend it. So I hope you found that useful. I'm now going to hand you back to Virginia to discuss ADR offers and handling the claim.
Thank you, Charlie. Well, if you've been following Charlie's advice, then you probably at this point have got a pretty good idea of what the claim is about. You've probably had a written commentary of the allegations from the insured, and you've got some idea of what the insured's response is or defence is. So you'll now be ready to weigh up those against each other, which I think brings me to the considering liability. Have you got all the documents that you need? Have you got the retainer letter or contract, if there is one? Is there a chronology? Have the right parties been identified? Do you actually understand what the insured does for a living? And I'm going to consider this in the context of my area of specialisation, which is professional indemnity negligence claims. When you receive the papers, you need to work out what has led to the claim. Perhaps it's an audit or some administration services. Don't be afraid to ask the insured what it was asked to do and whether it considers that it did that. Is it a breach of contract? Is there a written retainer? Did the insured get paid for what they did? How much did the insured get paid for the job? Even if there isn't a written retainer, there may still be a duty. How will that duty arise? I once had a claim where an insured said he didn't owe his client a duty because he was half cut at a friend's wedding when he gave the advice, and he gave it for free, and he hadn't set up a file. And sadly, I had to tell him that it didn't quite work like that. But are there any continuing obligations? Does the insured still have a relationship with its client? What was the scope of the insured's duty? Did the claimant rely on the insured's work? On what basis? Is there a breach of some other duty? Did the insured do something wrong? Is there any doubt? Is anyone else involved? Can the liability be shared? Is the claimant to blame? Use your own moral compass to guide you. Does it sort of pass the sniff test? If you don't understand it, either ask the insured, or if it's complex, then get an expert on board or appoint a panel to help you. You'll then move on to trying to work out causation and quantum. They're big words, and what do they actually mean? Well, causation is the link between the breach of the duty and the loss. Quantum is how much are we talking about? So in relation to causation, you need to consider whether the damage was foreseeable. Often when claimants sue, they focus on the fact that a duty was owed and that the insured in some way breached that duty. However, they often struggle with the issue as to whether or not the breach of duty caused any loss and what loss was caused by the breach of duty. It's a difficult area and often quite a grey one. One example that we get is where a claim comes in, for example, against an accountant for negligently advising on a tax structure. And the disgruntled client says that they were told to organise their affairs in such a way that they won't have to pay any tax. Then, nasty surprise, a great big tax bill turns up and the client can't afford it, hasn't planned for it, turns to his accountant and says, "You told me I wouldn't have to pay any tax. I relied on you. If what you'd said is right, there wouldn't be any tax, and therefore you pay it instead of me." The answer to that is that it might be that the tax was payable in any event, and that there's no other way to structure one's affairs to avoid a tax. Or potentially that the choices, had the client been given the right advice, the choices are not ones that the claimant would have realistically made had they been given the correct advice. In contract, you have to consider whether the loss was of a type that could be said to have been reasonably within the contemplation of the parties at the time the contract was made. In negligence cases, the loss needs to be foreseeable. You can't claim for losses that couldn't possibly be expected to be flowing from that error or omission. So, is there any potential liability by third parties? Another area to consider. Any intervening causes? For example, a client might have moved shares from company A to company B on negligent advice. But what if keeping them in company A would have resulted in the same or worse losses? What if the client had a track record of making risky investments and would have done it even if the advice had been sound? These defences can be quite difficult to get off the ground, but they do need to be explored. In quantum, obviously, you need to identify what damage has been suffered. What's the loss? Does it include interest? Have you allowed for the claimant's loss? Has there been a delay in bringing the claim? What about the claimant's costs? Is expert evidence needed to ascertain the loss? What rate of interest is claimed? Once you've got answers to all of those questions, without needing more information, then you've probably got a pretty good idea of what the claim's worth, and you're now ready to set down a strategy towards resolving the claim. ADR and offers. What does ADR stand for? Alternative Dispute Resolution. Another way of settling the claim other than taking it to trial, if you like. Reading between the lines when you first receive a claim, you need to think about what the claimant wants. There should be a letter of claim that gives you a sense of what they're trying to achieve from making their claim. Is it a fix? Is it an apology? Is it money? How much? It can help to resolve the matter if you make a note of your first impressions. Sometimes I find myself coming back to those when I'm quite a long way through the case. How does the insured want to handle the claim? What can they tell you about how the matter has escalated? Would it be best to take it out of their hands or to hold their hands through it? Is the person you're dealing with the best person to be dealing with this? Are they the one facing the claim, or is there another partner or director, perhaps with some more objectivity, dealing with it? Do they have a sensible head on their shoulders? This might inform your view as to how you want to handle it. Once the claimant set the ball rolling, there's no particular magic wand to get rid of the claim, unless you have a very, very strong defence. So you have to consider the options. Those options might be an apology and an offer to put things right. This isn't always going to be realistic or possible. Might be a meeting to find out more or to work out how to resolve it, in which case you need to think about who should attend that. Should it be a small and friendly meeting with the insured and the client, or should it involve all the lawyers and bring out all the big guns? How do you go about it? Would that be too aggressive? What about an offer to settle? At what level? Should you do that in writing or over the phone? Should you get a feel for how much the other side would accept before putting it in writing? Getting an independent opinion. This could be from an expert or by way of an early neutral evaluation. Could have a mediation. Won't be appropriate for very small claims, but it can be useful as a more formal way of diffusing tension and achieving a deal, particularly in the more complex or expensive claims. And finally, If you have a very strong case and it's worth the money, or you simply need to have a point decided because you've got several more like it, then a trial, a judgment, a hearing, arbitration, final award, final determination from a court of law is what you need. The costs of each option clearly need to be weighed up. It's hard for insureds to accept that it's going to cost them even if they've done nothing wrong. In the same way that it will cost them money if somebody rams into the back of a car when they're stationary at a red light. They might be right, but they'll lose their no claims bonus. In my area of professional negligence, they need to think about whether or not the witnesses can cope with the stress and the time commitment of a trial. They can start off quite bullish until you tell them that you're going to need sort of 5 days of their time to prepare a witness statement and that they're going to be under oath and in the box for 3 days and they're going to be losing revenue as a result of doing that. So this has been a bit of a whistle-stop tour through claims handling. While we've been talking, hopefully my colleague Harriet Strevens has been collecting some questions that you may have asked. Harriet, have you got any questions for us?
Well, we do have quite a few in actual fact, but given our timing, I'm going to give you both one each and only seconds to answer both of them.
Okay.
So, Virginia, will there be a handout at the end of this?
Yes, there will. We've got a checklist which what we appreciate, rather than sending it to everyone, is when you complete the feedback questionnaire, which will follow this webinar, if you enter your details, we will email it to you. It might take a week or so to collate it, but yeah, we can certainly provide the checklist, yes.
And Charlie, does liability have to be crystallised before a demand for payment of the excess is made, is your view?
No, not necessarily. I mean, another lawyer's answer, it will depend on the terms of how the excess clause is written. I think it's the real thing to look at is whether the excess will include defence costs as well, because they will need to be incurred before the loss is crystallised.
Thank you very much for those answers, both of you, and back to you, Virginia, to wrap up, if I may.
Yeah, thank you. It really remains for me to ask you to complete the feedback, and feel free to include in that any topics that you would like us to consider speaking about in the future. Do connect with us on LinkedIn, and that this has been recorded. The recording will be available afterwards. So yeah, thank you all for tuning in. Goodbye. Thank you.